Who are the primary players in the bankruptcy process? It begins with the debtor and then the creditors of the debtor. Okay. And when the debtor files for bankruptcy protection, a bankruptcy estate is created. And an individual needs to be in control of that bankruptcy estate. So, in personal bankruptcies, whether it's a liquidation or a reorganization, a trustee is appointed or, in some cases, elected to manage the bankruptcy estate. And in business bankruptcies, in a liquidation bankruptcy, a trustee is generally appointed. But when you have a reorganization of a business, generally the debtor serves as their own trustee, or they're called the debtor in possession, and they serve the role of the trustee, which we'll talk about the role of the trustee in debt later, beyond the simple fact that they manage the bankruptcy estate, they collect assets, they assemble debts, and they pay off debts and do whatever is necessary with the assets to comply with the liquidation or reorganization plan. So in that way, that's the role of the trustee in this process. And then you have the bankruptcy court. The bankruptcy court has the authority to settle disputes, to accept or reject a plan of reorganization, and it's ultimately the bankruptcy court that grants the final disposition of the bankruptcy proceeding and a discharge of any indebtedness. So the authority and power, again, rest with the bankruptcy court, but the majority of the procedural aspects are carried out between the debtor, creditor, and if a trustee is involved, the trustee. Well, the bankruptcy court undertakes the legal procedural aspects for, again, orders of things that need to happen in the procedural process, the final discharge, and then, of course, resolving any disputes between debtors and creditors in the process.